This is all so messy. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. If Justin Baldoni was not stuck in the center of this legal mess that he's found himself in, he would most likely support publicly Liar Liar Blake's on fire and denounce the actions of the legal team representing her opponent, including what just happened. If you've been following my videos, then you are aware, most likely, of California Section 47.1. That's a fairly new law that was passed that was meant to protect real victims of SH from being slapped with defamation lawsuits. Well, Litigious Lively is arguing that California legislation in New York in federal court and recently urged her bestie, Judge Lyman, to apply that to her case and award her damages. And now we have just gotten quite the response from the Wayfarer parties. They say, for the second time, plaintiff Blake Lively seeks draconian relief under a new California statute, California Civil Code 47.1, which creates a qualified privilege for any person claiming SH under defined California statutes, including FEHA. What's FEHA? Hold on. Yes, I should have remembered this. The Fair Employment and Housing Act. That is a state law that protects against discrimination and harassment in employment and housing in California. But I'm still confused because nothing related to this saga went down in California. The film was made, promoted, being litigated in New York. And they filmed also in New Jersey. Unless I forgot, but how does California factor into all of this? It should be noted that New York does not have this kind of law on the books yet, but it might. And the Wayfarer parties continue in their response, saying Section 47.1 authorizes an award of reasonable attorney's fees, treble damages, and punitive damages for a failed defamation claim against a party asserting SH claims without malice, that's important, and with a reasonable basis to file a complaint of SA harassment or discrimination. Thus, whether the privilege and remedies afforded by Section 47.1 apply, turn not on the Wayfarer party's underlying conduct, but on Lively's motive and intent. Let me sit with that thought for a minute and see if I agree with it. I mean, I guess that makes sense. Okay, they explain. Okay. Let's read the next part. They explain, saying, whether Lively asserted the claims without malice and with a reasonable basis, factual issues that remain to be tried in the main case. There are two very interesting footnotes here. One, it says, the statute also applies to claims for violations of certain sanctions of California's education code, which are inapplicable here. And two, Baldoni's William Morris Endeavor agent, Danny Greenberg, testified, redacted. Testified what? Malice. I'm guessing, because it's a big black block. Malice, malevolent. I'm trying to think of a new nickname. As explained in Section 2A below, Section 47.1, that new law in California, the express language of that law raises multiple constitutional concerns which have not been addressed by any California or other court, including its curtailment of free speech and a litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble and punitive. There's a footnote here. It says, Section 47.1, which took effect on January 1st, 2024, has not been addressed in a single published judicial decision. Thus, any decision by this court on the interpretation and applicability of Section 47.1 would be of first impression. Holy hell. Judge Lyman is hating his life. He has been for a while now, but even more so now because this has very serious implications. The first time that this new law is being tried. And should it even be tried in federal court? This is a California law. I'm gonna guess Lyman might just shoot it down saying, federal court, sorry, because he does not even want to wade in this water. Ooh, and they bring this up. They mention it, saying, further, Lively does not explain why California's presumption against extraterritorial jurisdiction does not apply to Section 47.1. When Lively is not a California resident and the alleged harassment, which is the basis for her claims, occurred in New York and on the New Jersey set where It Ends With Us was filmed. As I said, in the future, I cannot wait to hear from Justin Baldoni. He's not spoken at all in 2025, except for a post for his wife and their anniversary. Maybe another post that I can't remember right now, but he's not commented on this saga at all. And I'm really curious. It might even be possible that in the future, he signs an agreement, a settlement that prohibits him from talking about everything, but he's not going to be prohibited from talking about issues like feminism, supporting women, believing victims, and if this all changed things for him. Because I think, as I said, the old Justin Baldoni would have believed Blake Lively and supported her. And thank God he came through with receipts, proof, timeline, screenshots, or else everybody would have just assumed she was saying the truth. And he'd be not having the support that he has now. Baldoni and the Wayfarer defendant's response continues, saying, Lively, the statute, Section 47.1, and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint, where the issues of liability and punitive damages have not yet been determined by the trier of fact. The extreme remedies created by Section 47.1 require factual findings that Lively asserted her claims without malice and with a reasonable basis. This inquiry turns on Lively's motives, to wit, whether her complaints of SH were made with malice and with a reasonable basis. Factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. Makes a lot of sense so far. They continue, no trier of fact has made these factual determinations, which are central to the Wayfarer party's defense and will be ultimately determined in the still pending main action. Although Lively contends that to be effective, the remedies should be imposed at an early stage of the litigation. Neither the statutory language nor its legislative history address the dismissal of a consolidated complaint before the complaint's SH claims are tried in the main action. A footnote here adds, the Wayfarer party's claims were initially filed as a separate action, but have now been consolidated with Lively's complaint. They continue, Lively nevertheless contends that Section 47.1's remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. Here, however, neither the dismissal of the Wayfarer party's defamation claim nor an award of penalties under Section 47.1 would achieve this statutory goal of preventing ongoing, protracted litigation over the same factual issues which determine the applicability of Section 47.1, to wit, whether Lively's claims are valid. No California court has provided guidance on this issue, California law. It makes no sense that a federal judge will provide the guidance, but hey, Ellen Garofalo, E.G., says, no California court has provided guidance on this issue, including whether a court's determination before trial, in the context of Section 47.1 of the complainant's motive and intent, would divest a defendant of his right to a defense at trial or by summary adjudication based on admissible evidence. Yeah, I believe women and support victims, but this California Section 47.1, while good intended, seems really problematic, right? Team Baldoni Wayfarer continue saying, the application of Section 47.1 to the dismissal of a consolidated complaint while the main action is still pending also raises the specter of inconsistent outcomes. For instance, if this court, Judge Lyman, applies Section 47.1's privilege and remedies at this early juncture, it feels like forever, what happens if a jury later finds her claims lack merit? Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the trier of fact. Very sensible, right? Lively, they continue, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegations of the Wayfarer party's purported misconduct, which are the basis for pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. Yes, that's still pending. Yes, Like E.G. said at the very beginning of this all, they already made a move for sanctions, and Judge Lyman has not ruled on that yet. And Ellen continues. The bulk of these allegations have no bearing on the discrete factual issues relevant to a Section 47.1 analysis, specifically whether Lively had a reasonable basis for her SH claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed the Wayfarer Party's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence that the Wayfarer parties spread negative stories about Lively. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Ryan Reynolds, Leslie Sloan, or the New York Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her SH claims. And the court did not dismiss the Wayfarer Party's defamation claim against Lively for failure to plead malice. Rather, the court found that Lively's complaint, the only basis for the defamation claim asserted in the cross-complaint, was privileged under California's litigation and fair report privileges, and thus it was unnecessary to reach the issue of malice. Translation: the judge, not even a jury, Lyman, at this stage, didn't rule on the substance of Baldoni's claims, which have sadly all been tossed in the garbage now. The judge just ordered that procedurally she was correct in how she did things, so he cannot sue her for all the reasons that she did, because that was privileged, protected. So he ruled that their lawsuit was done, but did give them the option to file a second amended complaint, which, for reasons we still don't know, the Baldoni Wayfarer parties decided not to do that. So they continue. Notwithstanding Lively's exhaustive rehashing of the full breadth of her allegations, the motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award the punitive remedies provided in Section 47.1 at this stage of litigation. Lively's motion should be denied because, among other things, Lively fails to show that Section 47.1 or California Civil Code 3294, California's punitive damages statute, have extraterrestrial application, meaning Judge Lyman can apply them in New York federal court. Additionally, Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under Section 47.1. I didn't remember that. Do you remember that? My brain is a little mushy. The court previously denied relief under Section 47.1? Okay. Additionally, they continue, no trier of fact has found, based on admissible evidence, that Lively's SH claims were asserted without malice and with a reasonable basis. Additionally, Lively fails to show, and no trier of fact has found, clear and convincing evidence the malice required for punitive damages as required by Section 3294. And plaintiff has not proven, and no trier of fact has found, the actual compensatory damages required as a basis to calculate treble or punitive damages. So, plaintiff's motion should be denied. No California, I'm gonna speed this up because I just want to make sure we don't miss anything, but I also don't want this video to last forever. So buckle up. Plaintiff's motion should be denied. No California or other court has addressed the constitutional concerns and conflicts apparent from the face of Section 47.1. Just the weight of this, the impact and implications of how Lyman rules or doesn't. Important. Plaintiff's motion implicates two California statutes, Civil Code 47.1, which applies to SH claims under certain enumerated California statutes, including FEHA, and Civil Code 51.9 and Civil Code 3294, California's punitive damages statute. Lively seeks remedies under California Civil Code 47.1, which provides for severe penalties for unsuccessfully. That should be underlined, italicized, and bolded for emphasis, but it's not. Lively seeks remedies under California Civil Code 47.1, which provides for severe penalties for unsuccessfully filing retaliatory defamations action against SH and retaliation complainants. According to plaintiff, the recently enacted Section 47.1 was intended to deter frivolous claims that force survivors to defend against long and expensive retaliatory defamations lawsuit by imposing significant remedies for success defendants in defamation claims. Was there a typo there? I read that verbatim. Imposing significant remedies for success defendants in Okay, they're quoting Lively, so I'm guessing she messed up in her filing, and was intended to protect victims from the litigation itself. As a preliminary matter, Lively does nothing to address the constitutional concerns and conflicts raised by Section 47.1's express language. Section 47.1 conflicts with the right to free speech and petition guaranteed by the First Amendment to the United States Constitution. Section 47.1 also clashes with the Noer-Pennington Doctrine, which provides that those who petition any department of the government for redress are generally immune from statutory liability for their petitioning conduct. By imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types, they are flipping this on its head. Fascinating, smart. In this little tidbit, they're actually advocating for SH victims, true ones that can actually prove that. They say, by imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types of lawsuits, even when they do so in good faith, Section 47.1 appears to trespass on the Noer-Pennington immunity doctrine. Second, plaintiff fails to address how Section 47.1 can be reconciled with California Civil Code 47B, which, consistent with the right to petition, creates an absolute bar to any defamation claim based on statements made in connection with a judicial proceeding. Specifically, Section 47B applies to any communication made in judicial or quasi-judicial proceedings. by litigants or other participants authorized by law to achieve the objects of the litigation, and that have some connection or logical relation to the action. The privilege is absolute and applies to all publications irrespective of their maliciousness. We already learned that with the New York Times in this litigation. It protects to publications made outside the courtroom and all torts except malicious prosecution. Third, plaintiff fails to explain how Section 47.1 should or can be applied when, as here, a defamation claim is dismissed. Very good. At the pleading stage, before the dispositive factual issues of whether plaintiff's claims were asserted with malice and without a reasonable basis, issues of fact within the province of the jury. In the same vein, they continue, Section 47.1's approach to punitive damages under California Civil Code 3294 is particularly troubling. Wow. Baldoni and Wayfarer are really going for the jugular with California's recently enacted Section 47.1. And this is the first time anywhere that law is being tested. As explained in Section 2E below, California has a long-standing rule that there is no right to punitive damages. Rather, punitive damages require clear and convincing evidence of malice, a determination left to the discretion of the trier of fact based on admissible evidence. And a reminder, yet again, malice has not been determined. Where a trier of fact finds that punitive damages are warranted, the Fourth Amendment's prohibition against excessive penalties limits such damages to a maximum of 3 times the actual compensatory damages awarded by the jury. The questions of whether Section 47.1 permits punitive damages to be awarded as a matter of right, or how punitive damages would be calculated absent an award of actual damages, where a defamation claim has been dismissed on a motion to dismiss, have not been answered or even addressed by any court. Dun, dun, dun. Nor does plaintiff explain, much less cite authority for how the court can calculate punitive or treble damages without an award of compensatory damages. The plethora of serious constitutional and other legal questions have not been addressed by any California court, raising the preliminary question of whether this court, her bestie, as a matter of first impression, should apply Section 47.1 to impose the draconian remedies of attorneys' fees, treble damages, and punitive damages without any answer to or even guidance on these critical questions and concerns. It may have been for some or all of these reasons that the court has already declined to award Lively the relief she seeks under 47.1, albeit without prejudice. In doing so, the court explicitly noted that it had not ruled on whether Lively's statements were privileged under California Civil Code 47.1, and that if Lively chose to renew her motion, she should fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. While Lively now resuscitates her motion with an extensive exposition of the facts asserted in prior pleadings and the order, she does not cite new facts or law relevant to whether she had a reasonable basis for her SH claims and whether her claims were asserted with malicious intent. Simply put, Nothing has changed since the order, and Lively and this renewed motion appears to be nothing more than an improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public. I'm glad I read this, because it adds a lot. Her new request is a improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. At best, the motion is premature. This court should decline Lively's invitation to interpret Section 47.1 as an issue of first impression in the dearth of any guidance from a California court and impose heavy-handed penalties, which would require this court to make premature factual determinations, which has not happened yet. I'm really waiting for that point, though. Additionally, plaintiff fails to show that Section 47.1 or Civil Code 3294 may be applied extraterritorially. That's such a mouthful. The threshold question is whether these California statutes have extraterritorial application, whereas here, the plaintiff is a resident of New York and the underlying conduct occurred in New York and New Jersey. The alleged underlying conduct, Ellen. The California legislature knows how to create exceptions when that is its intent, and when a statute gives no clear indication of an extraterritorial application, it has none. California recognizes a presumption that the California legislature did not intend a statute to be operative with respect to occurrences outside the state unless such intention is clearly expressed or reasonably to be inferred from the language of the act or from its purpose, subject matter, or history. Although proposed amici curiae offered in support of Lively's position quote extensively from Section 47.1's legislative history, Lively does not point to express language in Section 47.1 or any portion of the legislative history that even hints at an intent that the statute have extraterritorial application. In fact, Section 47.1 does not include any affirmative indication that it was intended to apply to conduct outside of California. Likewise, nothing in the legislative history of Section 47.1 indicates the legislature had any intent for this statute to operate outside of California. So Judge Lyman, don't even touch it. Don't even touch it. Because Section 47.1 is silent on the geographic scope of its application, and there is no expression of legislative intent for it to apply extraterritorially, the presumption applies in full force, and Lively, a non-California resident, cannot invoke it for conduct occurring outside California. By contrast, where the California legislature does see fit to provide for the extraterritorial application of California statutes, it says so. That was bolded and italicized. For example, California Labor Code 3600.5, extending workers' compensation to certain employees who are injured while working out of state. That makes sense. Absent the express or implied showing of an intent of extraterritoriality, Lively must establish a substantial connection between the situs, that's a mouthful as well, the situs, let me look it up, situs, the place to which, for purposes of legal jurisdiction or taxation, a property belongs. Okay, that makes sense. They say Lively must establish a substantial connection between the situs of the legally relevant conduct and California, specifically the location of where the core of the alleged wrongful conduct occurred. She can't do that. New York, New Jersey. A formulaic, conclusory, blanket recitation of ratification is insufficient to overcome the presumption absent facts sufficient to establish a factual nexus between the defendant's California-based activities and the allegedly wrongful conduct. New York, New Jersey. Nor does a contractual choice of law provision, that's where it came from, nor does a contractual choice of law provision, you see, this is also why you read everything. Sometimes you need reminders. Nor does a contractual choice of law provision overcome the presumption that a California statute lacks extraterritorial reach. Neither Lively's complaint nor the motion state facts sufficient to establish a substantial connection between the Wayfarer defendant's unsuccessful defamation complaint filed in and dismissed by a New York court or the underlying SH claim, which would give rise to the privilege she seeks to invoke. Lively is a New York resident. The core conduct, alleged SH on the It Ends With Us set, and the filing and dismissal of the Wayfarer party's unsuccessful defamation claim, the basis for Lively's request for remedies under Section 47.1, did not occur in California, but in redacted. Why'd they redact that? Who cares? I'm guessing it's some city in New Jersey, Jersey City, Hoboken, Weehawken, Trenton. While Wayfarer is headquartered in Los Angeles, the employee or employer's residency is not sufficient to overcome the presumption when the torturous conduct is outside of California. The failure to demonstrate a substantial connection between the situs of the core conduct and California defeats any notion that sections 47.1 or 3294 can be applied extraterritorially. Because she cannot overcome the presumption against extraterritorial application of Section 47.1, Lively's request under Section 47.1 should be denied. Additionally, Section 47.1 cannot apply whereas here there are no factual findings that Lively's claims were asserted without malice and with a reasonable basis. Section 47.1 creates a privilege for communication made by an individual without malice regarding an incident of SAH or discrimination is privileged so long as the speaker has or at any time had a reasonable basis to file a complaint of SA harassment or discrimination. The Wayfarer defendant's defamation claim was dismissed pursuant to Rule 12b-6 for failure to state a claim. The order dismissing the claim expressly states that the court did not consider whether the Wayfarer parties pleaded malice but dismissed the claims based on privilege grounds. Plaintiffs' harassment claims remain pending, and the merit of those claims, as well as Lively's motive and intent in asserting them, will ultimately be decided by a trier of fact, a jury, or the court in the context of summary adjudication. Indeed, a centerpiece of the Wayfarer party's defense is that Lively's claims have no merit and were asserted for an improper purpose: to take control of the movie. And I would say retaliation against him for not giving her what she wanted. The jury must resolve the threshold question of the defendant's knowledge of facts on which his or her claim is based. Plaintiff does not explain how the court might eliminate the risk of inconsistent findings on the pivotal issue in this case, Lively's harassment claims, should this court prematurely decide that Lively's SH claims were asserted without malice and with a reasonable basis. Nor does plaintiff provide any authority for the notion that the Wayfarer defendants can be stripped of their rights to a defense at this early juncture in the context of a Section 47.1 motion. Lively similarly fails to identify new facts that might support her motion. Plaintiff merely resuscitates the allegations set forth as the basis for plaintiff's pending motions for sanctions under Rule 11 and New York Rule of Professional Conduct 3.6. Now, I'm not a lawyer, but that feels like double jeopardy, right? Am I using that correctly or not? I'm in my Elle Woods era, but not quite yet a lawyer. The bulk of the allegations have no relevance whatsoever to this motion, which is not about the Wayfarer party's motives or conduct, but about Lively's motive and intent. In fact, Lively's motion is laden with extraneous and irrelevant facts. For instance, Lively argues that Wayfarer's defamation claims against Ryan Reynolds and Leslie Sloan were dismissed for failure to plead malice. Lively ignores that even assuming a pleading defect can be the basis for Section 47.1 remedies, the court did not base the dismissal of the Wayfarer party's defamation claim against Lively on this ground, but rather on the ground that it was subject to California's litigation privilege and the fair report privilege. Lucky New York Times. Plaintiff has not proven that she is entitled to punitive damages under Section 3294, while a plaintiff who proves his case is always entitled to actual damages. A plaintiff is never entitled to punitive damages as a matter of right, not even upon the clearest proof of malice in fact. For an award of punitive damages under California Civil Code 3294, a plaintiff must prove by clear and convincing evidence that the defendant acted with malice, oppression, or fraud in bringing their defamation cross-complaint. I don't think they did. And remember, the judge has not ruled on the merits of their claims, just the technicalities of. You can't even argue that because how she made her complaints, that was protected. Malice is defined by Section 3294, subdivision C1, as conduct which is intended by the defendant to cause injury to the plaintiff, or despicable conduct which is carried on by the defendant with a willful and conscious disregard of the rights or safety of others. Despicable conduct is conduct that is so vile, base, contemptible, miserable, wretched, or loathsome that it would be looked down upon and despised by most ordinary, decent people. I'm sure she would argue that that has happened here. Conscious disregard means that the defendant was aware of the probable dangerous consequences of his conduct and that he willfully and deliberately failed to avoid those consequences. Put another way, the defendant must have actual knowledge of the risk of harm it is creating and, in the face of that knowledge, fail to take steps it knows will reduce or eliminate the risk of harm. In the defamation context, to show actual malice, plaintiffs must demonstrate a defendant either knew his statement was false or subjectively entertained serious doubt his statement was truthful. I really think he believes everything he said. And I'm not sure if she believes everything that she said. Maybe. I think she does. But I'm not sure. The clear and convincing standard presents a heavy burden far in excess of the preponderance sufficient for most civil litigation. The burden of proof by clear and convincing evidence requires a finding of high probability. The evidence must be so clear as to leave no substantial doubt. It must be sufficiently strong to command the unhesitating assent of every reasonable mind. Whether a defendant acted with malice is an issue of fact for the jury, and it is within the exclusive province of the jury to say whether or not punitive damages shall be awarded, and the granting or withholding of punitive damages may not legally be influenced by any direction of the court. Plaintiff simply ignores the requirements that malice be proven with clear and convincing evidence. Any finding of malice and punitive damages is within the exclusive province of the jury, and the court is prohibited from influencing the jury's decision on whether to award punitive damages. Instead, plaintiff avers that as for punitive damages, the record as it currently exists is sufficient for the court to determine the wayfarer parties engaged in oppression, fraud, or malice by bringing or maintaining their claims against Miss Lively. This argument, while facile, is contrary to the law. Before I look it up, I think facile means easy. Let's see. Facile, appearing neat and comprehensive only by ignoring the true complexities of an issue. Superficial. That's a good word. Damn. Plus, plaintiff fails to explain how, in the absence of actual damages, the court can calculate punitive or treble damages. Punitive damages typically require a finding of actual compensatory damages. An exception exists where a plaintiff is entitled to recover presumed damages. Neither Section 47.1 FEHA nor Title VII provide for presumed damages. Hence, an award of actual damages is a predicate for any award of punitive damages. There has been no award of actual damages after a trier of fact has found liability, because that hasn't happened yet. Plaintiff similarly fails to explain how the court can calculate treble damages absent a finding of actual compensatory damages. Put another way, what exactly would the court be trebling? Conclusion. For the foregoing reasons, the wayfarer parties respectfully request that the court enter any order denying Lively's motion for relief under Section 47.1. Respectfully submitted. Whoo, child. The hardcore feminists, the hardcore litigious Lively supporters are going to be foaming at the mouth over this. Quite the response. And everyone should go right now to buypopstuff.com. Check out my new merch. I don't want to say what it is, but I've got 2 new similar collections that I think you're going to love. Buypopstuff.com. Buypopstuff.com. And check out all my other merch. Make sure you scroll through all the pages at buypopstuff.com. Also, don't miss a thing. Stay informed and entertained, and get an exclusive podcast a week that we offer to our Patreon subscribers. Sign up right now on the Patreon website at patreon.com/P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. Also, I have thousands of glowing reviews on Cameo. Get a personalized video from me for yourself or for anyone, for whatever occasion, right now on the Cameo website at cameo.com/P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. And thank you for watching till the end. If you are here still, you are the 1%. You are the VIP member of my fam. Hit that like button. Leave a comment down below. Say rainbow. And I am so anxious to hear your thoughts on this latest filing. I can see both sides, and I want to hear them all in the comments section. Rainbow, see you there.